Hi everyone, my name is Chelsea Kennedy. I'm the Executive Practice Coordinator here at Butler Wills and Estates, and today we are going to be taking a detailed look at the first of 5 common estate planning misconceptions. Misconception number 1. Adding your child's name to your home or bank account is a good estate planning move. Why do people do this? A lot of the time, people are trying to avoid probate and trying to reduce the probate fees. Also, people are trying to keep things simple or avoid having to make a will altogether. Sometimes people do this because they want help with the banking because mobility is an issue. Also, a lot of parents tell us that they want to ensure that their kids have access to some money after the parent passes away. So, why is this a problem? There is a huge risk to the parents of the loss of the home while they're still alive. For example, let's consider a parent who adds their child's name to their home, and the child gets divorced. On paper, it looks like that child owns the home, so in the divorce, the child could lose their home. However, because it's a jointly owned asset, it's also the parent's home. So unless the parents have enough money to buy out their house again, they might lose their house in their child's divorce. The courts don't recognize that it's really mom's house. On paper, it looks like the child owns the property. Also, it creates new tax for the kids where there was no tax before. For example, if your property is your principal residence, when you pass away, it is not subject to capital gains tax. However, if you add your child's name to the property and it is not the child's principal residence, their share of the home is subject to capital gains tax. So essentially, you've created a tax liability where it didn't exist before. Also, adding a child's name to an asset creates confusion if it contradicts what's in your will. And this doesn't work the way people think it should. Adding a name to an account creates ownership. In theory, this means the child inherits the account when you pass away. It creates expectations on one side and resentment on the other. It also creates questions about your intentions. Jointly held assets, whether property or bank accounts, between a parent and a child are treated differently than jointly owned assets between spouses or people of the same generation. Before 2007, jointly owned assets were the same no matter whose name was on them. However, in 2007, the Supreme Court of Canada ruled that intergenerational joint assets, whether between a parent and a child or a grandparent and a grandchild, are treated differently. This is because of the increase in incidents of elder abuse. Now, if an asset is held intergenerationally, the asset must be held in the parent's estate until it can be proven what the parent's intentions were for that asset, whether they want the child to own it outright or if the child was added for convenience. So, what can you do instead? If you do want help with the banking, use a power of attorney. The bank can provide one for you, or if you want a more detailed, custom document, visit an estate planning lawyer. And if you do want your child to inherit the account or the property, make sure you confirm this in your will. Today, we talked about adding your child's name to an account or a piece of property, and why this is an issue and what you can do instead. Stay tuned for next week's episode where we take a look at the second of the 5 most common estate planning misconceptions. Where to find us? Visit us on our website at butlerwillsandestates.com or check out our blog, estatelawcanada.blogspot.ca, or to get in touch with our office directly, give us a call at 709-221-5511. You can also send me an email at chelsea@butlerwillsandestates.com.